Impeachment is a mere sham, a mere farce. That was Patrick Henry in 1788. But here's the thing. He wasn't trashing impeachment because of what it was designed to do. Instead, he was predicting it would never work the way the Federalist side promised. So on this episode, I'll walk you through just what the framers actually designed, a tool to guard the Republic, where it came from, how they described it during the ratification debates, plus 7 broad categories where impeachment can be used under the Constitution. Then we're going to circle right back to Patrick Henry, plus George Mason and Thomas Jefferson, and you can decide who was right. But first of all, before getting to that, welcome. And thank you for joining me here on the Path to Liberty. My name is Michael Bolden with the 10th Amendment Center, and this is the show for Friday, July 18th, 2025. Let's get right to it. First of all, not all the framers at the Philadelphia Convention were actually on board with the impeachment power right off the bat. But once the dust settled during the debates, they agreed on a plan that was intended to guard the Republic against serious abuses of public trust. Here's how Michael Stokes Paulson put it. He said, the power of impeachment was meant to be formidable. The framers of the Constitution understood impeachment as a vital, potent legislative check on abuse or misuse of power or other serious misconduct. A critical part of the Constitution's separation of powers, checks and balances scheme. So let's first look at the so-called impeachment clause. This is Article 2, Section 4 of the Constitution. The President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. Sounds pretty straightforward, doesn't it? But here's what most people miss. And back to Paulson. If the power of impeachment is taken seriously, and that's a big caveat, that big if there, and on terms consistent with its original meaning and evidence of historical understanding, another big if, but we're trying to correct that here today, that power, he wrote, must be understood as an intentional and formidable legislative check on judicial power as well as on executive power. Now, the framers designed impeachment to be extraordinarily broad, especially in comparison to how most people describe it today, covering not just statutory crimes, crimes on the books, but any serious abuse of power. And Paulson explains that impeachment plainly is not limited to commission of ordinary criminal law offenses. And the historical evidence, he says, in support of this is really quite overwhelming. I'm going to go through some of that, plus the 7 categories. But the broad point he wrote is that the constitutional power of impeachment covers a good deal more ground than ordinary criminality. And it's important to point out that the framers intentionally made the impeachment process pretty difficult to use. First, they distributed the power. The House and the Senate each had different roles to play. Here from Article 1, Section 2, Clause 5, the House of Representatives shall have the sole power of impeachment. Some people might be thinking, well, if it just goes to the House, what's the Senate for? Well, the impeachment part is in the House. You get a vote to impeach, yes or no. And then if the impeachment goes through, then you have to have the Senate try it and decide whether or not to remove from office. And that was another way that they made it difficult. It required 2/3. And this is Article 1, Section 3, Clause 6. The Senate shall have the sole power to try all impeachments, and no person shall be convicted without the concurrence of 2/3 of the members present. And then on top of it, to make it super, super clear that this was basically an emergency, it's kind of a safety net to get people out of office who needed to be gotten out of office without waiting on the normal course of affairs, like a retirement, stepping down, someone passing, the next election cycle. The entire process for impeachment is about removal. It's not about convicting someone of a criminal act. And here from Article 1, Section 3, Clause 7, judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. And the evidence on this broad understanding of the impeachment power, and we're going to get to more detail here going forward here, it comes to us from three distinct historical layers. The tradition where they got the impeachment power from, that was the British or English tradition. The Philadelphia Convention, how they debated how they were going to frame it. And then most important in my mind, the ratification debates, because those are the people who gave the Constitution its legal force. So their understanding of what the Constitution means is, well, what the Constitution means. And here back to Paulson. It follows from the historical meaning of the Constitution's impeachment standard that Congress legitimately may exercise the power of impeachment for a broad range of what it judges to be culpable misconduct by national officers. And again, I've got 7 categories from Paulson's amazing research on this near the end of the show, not at the very end. But first, we got to do a little bit of detective work and go back in time to understand where they got this. And first, these 3 layers of his history. First, the English or British inheritance. And back to Paulson, he said the evidence of original meaning overwhelmingly supports the conclusion that at the time of the framing of the Constitution, the composite term, high crimes and misdemeanors, was a well-established, familiar legal term of art. So this was well understood. People knew what this phrase meant. They were familiar with it. It wasn't just some weird text from an old book or something that maybe we heard a line about in grade school or something like that. They were familiar. The framers and the general public probably was pretty familiar with this as well. The composite term high crimes and misdemeanors was a well-established, familiar legal term of art that the framers consciously and very intentionally borrowed from long-standing English practice and usage dating back 4 centuries. This is old school stuff. They weren't just, when James Madison some years later talked about the Constitution and its ancient phraseology, that was his term for it. He wasn't messing around because they were using terms that had been used for hundreds of years. And in the British system, impeachment for high crimes and misdemeanors covered a lot, and that was not limited to just statutory crimes, statutory criminal acts. It also covered a wide range of political offenses, for lack of a better phrase. And Paulson puts it like this: the House of Commons had impeached and brought before the House of Lords for trial officers of the Crown, including ministers and judges, that they believed had violated the Constitution or laws. So violating even the unwritten British system, the Constitution, could get you impeached, or subverted the rights of Parliament or the system of government, abused or misused power, failed to perform the duties of office faithfully and competently, engaged in self-dealing behavior or misuse of funds, or were guilty of oppression, corruption, or other misbehavior or maladministration. Maladministration is a very important term when it comes to the founding generation as well. And here from Raoul Berger, rest in peace, Raoul Berger's great book on impeachment back from the 1970s. It's like 73 or 74. He explained why the phrase was so important. He said, in English law, from which our impeachment is borrowed, high crimes and misdemeanors were offenses against the state, like treason or bribery, triable by Parliament under the law of Parliament. But, and this is an interesting caveat, we think of it a misdemeanor as like a lesser crime in comparison to a felony. But he said, when high crimes and misdemeanors was first employed, there was in fact no such crime as a misdemeanor. And this is part of why we call the phrase high crimes and misdemeanors a term of art, a legal term of art. And as Paulson points out, Berger's book proved that the term high crimes and misdemeanors, they did all kinds of surveys on how the term was used throughout history. It was only used as a phrase for parliamentary impeachment. He showed, wrote Paulson, that high crimes and misdemeanors was a term the historical usage of which was confined to the jurisdiction of parliamentary impeachments. Its roots were distinct from the ordinary criminal law, which adopted the terminology misdemeanor later. Now, of course, the founding generation, the framers, the ratifiers, all these people, they were familiar with all this. They knew this history very well because they did a lot of reading, especially things like Sir William Blackstone's Commentaries on the Laws of England. Here, for example, this is how Blackstone put it. Misprisions, which are merely positive, are generally denominated contempts or high misdemeanors, of which the first and principal is the maladministration, again, that term, of such high officers as are in public trust and employment. This is usually punished by the method of parliamentary impeachment. So Blackstone is explaining, high misdemeanors are punished through impeachment, not through the normal criminal law. And then Blackstone got even more specific about what this looks like. He condemned in strong terms a particular, quote, offense against public justice, which is a crime of deep malignity. And especially so because there are many opportunities of putting it in practice, and the power and wealth of the offenders may often deter the injured from a legal prosecution. And that's what led to, well, of course, impeachment. That offense, of course, is, quote, the oppression and tyrannical partiality of judges, justices, and other magistrates in the administration and under the color of their office. And so those offenses against public justice, against the society as a whole, against the state, whatever you want to call it, are prosecuted by impeachment in Parliament in most situation. Now, there was a very, very long pattern of the British using this power purely for political offenses. They did use it for criminal ones as well. And I've got a law review paper, You're Fired, the original meaning of presidential impeachment, up on the screen here. This is going to be linked to in the show notes. I'll mention that again in just a moment. Some of these examples that the founding generation were all very familiar with. There was a treasurer who was impeached for wasting the king's money on unnecessary pensions. A lot of people would qualify. Or that same person for removing commissioners who opposed his plan. A chancellor got impeached for allowing abuses in his court that impeded justice or rendered it venal, is how they put it. Bishops were impeached for acting contrary to the king's prerogative. And this history, this understanding of how the British used the impeachment power and the term high crimes and misdemeanors, well, it directly influenced a pretty pivotal moment at the Philadelphia Convention when the framers were debating things. We got to go back to September 8th, 1787. We're actually getting close to the end of the Philadelphia Convention, and the draft of the impeachment power at that time only included impeachment for treason and bribery. And George Mason thought this was way too narrow. It would never, ever be used. And it wouldn't reach, quote, attempts to subvert the Constitution. It was very essential to have in the impeachment power the ability to get rid of someone, get someone out of office when they subvert the Constitution. So he moved to add after bribery or maladministration. Now, James Madison, on the other hand, he wasn't too big of a fan of including that in the Constitution. He thought it was way too broad. And Governor Morris, on the other hand, really didn't care one way or the other. He was like, it doesn't even matter. But here, from Madison's notes, again, this is September 8th, 1787. So vague a term will be equivalent to a tenure during the pleasure of the Senate. So Madison's concern here, the father of the Constitution, was very concerned that if you just said specifically for maladministration, rather than understanding high crimes and misdemeanors was a type of maladministration that was really, really bad, if you just had for any maladministration, it would be used as a political weapon, and the executive branch would definitely not be independent, would just be basically a tool of the Senate. That was his argument. Governor Morris, on the other hand, said, who cares? It's not going to be put in force, he said, and can do no harm. An election, this is funny to me, I'm sorry, I shouldn't be laughing. An election every 4 years will prevent maladministration. Put whatever you want in there for impeachment. Who cares? We got an election every few years, so we don't have to worry about one way or the other. So anyways, Mason ends up withdrawing the term maladministration, and he substituted that English legal term of art, other high crimes and misdemeanors. He included against the state. They had some debate over it, and they ended up with high crimes or other high crimes and misdemeanors. Now, for the framers in Philadelphia, this kind of struck the perfect balance. It was deliberate. It wasn't accidental. They thought about it. They debated it. Other than Governor Morris, who thought, well, who cares? It doesn't matter. It was broad enough to catch really bad abuse, but it was still specific enough that, you could go after tyranny, but it wasn't going to be used as a weapon. Now, maybe they made it too specific, but we'll get to that in a little bit. Now, I know I'm going through a lot of really kind of deep and detailed historical information here, and I'm going through it pretty quickly. There's actually a lot more here. So my goal with this episode is that I hope it serves as a bit of a highlight reel for you, and it generates a little bit more interest into reading and learning more from some of these sources that we're citing here. And if you're that kind of person, you're definitely in luck because the 10th Amendment Center's got your back. Every single episode, we publish a blog post that gives you all the references that I'm mentioning in the show. Well, as long as I've done a good job with my show notes. Alan Mosley does an awesome job getting that organized promptly and just kind of clearly. And he's going to have below, I'll get it published a couple of hours after the live stream is done over at 10thamendmentcenter.com/path to liberty. And you'll see it pretty clearly there. The top part is going to give you the title and overview. Plus, then you have the video player and the audio player. Then you have a show links section. And again, if I did a good job with my notes today, Alan will put those reference links generally in the order that I go through them in the episode. Again, that'll be published over at 10thamendmentcenter.com/path to liberty a couple of hours after the live stream is done. Let's get back to it. We've been talking about the debates in the Philadelphia Convention, Mason, Madison, Morris. But here's the kicker about that. What they said about it in Philadelphia actually had zero impact on the original legal meaning of the impeachment power on anything in the Constitution. And the reason is very straightforward, because the proceedings in Philadelphia were kept secret until Madison's death. I think it was like 1836. Instead, the important part is we have to look to the ratification debates to understand the meaning of the Constitution, because those are the people who gave it legal force. And that's just how the father of the Constitution put it in a letter to Henry Lee. He said, "I entirely concur in the propriety of resorting to the sense in which the Constitution was accepted and ratified by the nation. In that sense alone, it is the legitimate Constitution." And when it comes to impeachment power, I think the most famous, the most widely read was Alexander Hamilton in Federalist number 65. Maybe not during the ratification debates in and of themselves, but this represented the view of the Federalists that was getting spread all around. And Hamilton put it like this: "The subjects of its jurisdiction," talking about impeachment, "are those offenses which proceed from the misconduct of public men. Or in other words, from the abuse or violation of some public trust. They are of a nature which may with peculiar propriety be denominated political." And Hamilton went all caps on political, "as they relate chiefly to injuries done immediately to the society itself." Now, Edmund Randolph also weighed in on this during the Virginia ratifying convention. He was the first attorney general under George Washington. And he was one of 3 people in Philadelphia who actually didn't sign the Constitution. He ended up turning out to be an advocate for ratification later on. But here's how he put it: "If," said His Excellency, the governor, of course, "he be honest, he will do what is right." Now, Randolph's the governor. He's not talking about how this plays out. "If the president is honest, he will do what is right. If dishonest, the representatives of the people will have the power of impeaching him. So just for mere dishonesty, Randolph is saying, well, they have the power to impeach him. And George Nicholas, he actually brought things back to George Mason's original language, which was how Blackstone described the power of impeachment under high crimes and misdemeanors. Nicholas said the president himself is personally amenable for his maladministration. The power of impeachment must be a sufficient check on the president's power of pardoning before conviction. And if you think that and maladministration in and of itself was broad, just wait till you hear what Edmund Randolph had to say a few days later. At the end of 4 years, he may be turned out of his office, talking about the executive. If he misbehaves, he may be impeached. And in this case, he will never be reelected. So for Randolph, he's talking specifically about misbehaving. I wish more of us had that attitude about politicians because they all misbehave all the time. Anyways, back to it. North Carolina ratifying debates. A number of people talked about this. For example, Richard Speight, who was a signer of the Constitution, and I think he was later a governor in North Carolina. I'm not 100% sure. But he even suggested that just the misuse of the military could qualify for impeachment. He said Congress, who had the power of raising armies, could certainly prevent any abuse of that authority in the president, that they alone had the means of supporting armies, and that the president was impeachable if he in any manner abused his trust. So the misuse of the military, maybe using it in ways that violate the Constitution, would be an abuse of the trust delegated to the executive branch. That's impeachable. These are just a few examples of many people defining and describing the impeachment power during the ratification debates. Others include people like James Iredell, one of the first associate justices on the Supreme Court under George Washington, Samuel Johnston, James Madison, and others. They repeatedly took the position, on the one hand, that impeachment was a tool not just for criminal acts, so it was much broader than that, but on the other hand, it shouldn't be used, or it's not authorized to be used, for just mere policy disagreements. Here's how Paulson put it. There is no record of any substantial disagreement as to the scope of the impeachment power in the ratification debates. So as they were explaining these things, people weren't actually responding by saying, oh, no, you got to keep it to just criminal power, or it's way broader than what you're describing. You weren't getting real debates over the scope of the power. There was a controversial thing. For example, here, Paulson explains what was controversial, what apparently needed defending, and is therefore the principal theme of the Federalist essays on impeachment, was the decision to vest the final power to apply such a sweeping standard in the Senate. The Senate would try impeachments, and all the founders were fully on board with the celebrated Montesquieu and his explanation of separation of powers. The Federalists and Anti-Federalists disagreed on what qualified as separation of powers. The Federalist side said you can have, as long as it isn't just the totality of powers, executive, legislative, and judicial being combined in the same hands, or two of them in the same hands, you can have kind of some crossover. The Anti-Federalists were much more strict in saying, in general, saying that you have to have them completely separate. So a lot of the Anti-Federalists were very concerned. They're saying, oh, well, the Senate is part executive in some ways because they're basically approving nominations or they're involved in the treaty process. And the executive is part legislative with the vice president coming in for a tiebreaker vote. But one of the big things when it came to impeachment was that the Senate would be basically acting in the judicial realm, just in impeachment. But in and of itself, they were very, very concerned about that. I'm not going to get into any detail on that, but just wanted to point out that it was really a separation of powers debate in most situations. But when you put it all together, and you look through all of the historical records, and Paulson does a really great job. Of course, all of his articles on this, there's a whole series of like 8 or 10 of them. We'll get some primary ones linked to in the show notes. We have 7 very broad general categories of offenses which fall under the legitimate constitutional power to impeach. And let's get through these 7 pretty quickly. Well, let's power through them. First of all, number 1, Oh, wait, I got to switch the screen. Serious or serial violation of the Constitution or departure from sworn constitutional duty, like an ongoing violation of one's oath of office, an oath to defend the Constitution. If you do that on a consistent or serious or serial way, well, that's grounds for impeachment. Number 2, misuse or abuse of constitutional powers actually possessed, using them for abuse. 3, a serious failure in performance of the constitutional responsibilities of the executive or judicial office, like whether they're doing it through affirmative acts or wrongfully omitting some action or evidencing culpable negligence or incompetence is how Paulson describes it. Number 4, betrayal, compromise, or abandonment of the national interest. And he described it as disloyalty, falling short of treason. It doesn't rise to the level of treason, but it's disloyal, or it's an intolerable conflict of interest between an officer's personal or financial interests and the duties of office. Number 5, and this is a biggie, violation of the public trust. I think this kind of ties in. A lot of these are very similar, but this also ties into the oath of office. But he thinks, or he describes it, Michael Stokes Paulson describes it by dishonesty or lack of integrity in public behavior, like self-dealing or corrupt conduct in any of a variety of forms, like receiving or giving kickbacks or payoffs, or the dishonest use of funds or awarding public benefits, which are short of bribery. So you could have treason or bribery or things that are kind of along those lines, but you can't get convicted for one or the other. Number 6 is serious, willful criminal law violations. It's not just going to be like, I don't know, like not paying some ticket or something and then it turns into a misdemeanor. That's not a high misdemeanor. And then number 7 is serious non-criminal misconduct or misbehavior. Like, as Paulson explains, misuse of office for personal gain, pleasure, or entertainment. And ultimately, as he explains in his papers, this is far more broad than almost anyone understands the impeachment power in modern times. But whether people understand it correctly or not doesn't change the Constitution, and that's what he gets to here as well. He said the fact that many persons may have come to view the impeachment power is narrower than the Constitution in fact allows, or may hold mistaken understandings of its full scope, does not matter to the existence and extent of the constitutional power itself. So just because everybody gets it wrong, even if it's everybody except you and I, well, the Constitution is the Constitution, whether it's been ignored all along or not. The rules remain the same. And it's just up to us to try to educate ourselves and others. Paulson continues, it testifies only to mistaken views and flawed understandings. Where popular or conventional understanding is incorrect, it is that understanding that needs to change, not the meaning of the Constitution. Now, one argument that we always hear whenever we describe or discuss a broad power to impeach under the Constitution is, oh, well, it's just going to be a bunch of partisan hacks using it that way. And, well, no kidding. That's nothing new. In fact, it was expected, and Alexander Hamilton himself expected it to play out like that in Federalist 65. This was his paper explaining the power of the Senate, and they felt, or at least this was the description, was yes, this is going to be a super political process. You're going to have factions. People are going to be for or against impeachment based on which team is in power or who's being impeached. But the way that you kind of mitigate against some of that is to actually have the removal of proceedings in the Senate rather than in the House. Anyways, here's how Hamilton put it. The prosecution of them for this reason will seldom fail to agitate the passions of the whole community and to divide it into parties more or less friendly or inimical to the accused. So as soon as you have an impeachment proceeding, people are going to go into parties and factions for or against it based on, well, whatever team there is. So Hamilton understood human nature as well, even Hamilton. He said in many cases, it will connect itself with the pre-existing factions and will enlist all their animosities, partialities, influence and interest on one side or the other. And in such cases, there will always be the greatest danger that the decision will be regulated more by the comparative strength of parties than by the real demonstrations of innocence or guilt. And it's almost like Hamilton was basically telling us, oh, this isn't going to work the way that we're describing. It's just going to be a political tool. It's just going to be factions for or against. You're really never going to determine whether someone was guilty and needed to be removed. This is just a matter of pure politics. It's almost like he's giving us a warning here. And I think if you think about it, here's the real thing. The whole process, the goal, all of it sounds pretty good in theory, but in practice, it has not played out the way the Federalists promised it would play out. Impeachment, of course, is almost always political. Hamilton was very honest on this one. Not always his best trait was honesty. But on the other hand, we live under the largest government in the history of the planet and have so for a long, long time. So if we're thinking about a constitution that delegated powers that are few and defined to the federal government, reserved everything else to the states or to the people, that means pretty much everyone has always been liable to be impeached, but yet not one single president has ever been successfully removed under the impeachment power. And Patrick Henry, let's get back to Patrick Henry here. Because during the Virginia Ratifying Convention, he was specifically saying that the British system was actually really effective. It provided real accountability. But he thought the changes in the American system under the proposed Constitution at the time, it put the final decision into the hands of the Senate and would have really bad results. Here, I'll just give it to you in his words. But I beg gentlemen to consider the American impeachment. What is it? It is a mere sham, a mere farce. And George Mason explained one way this would play out. Basically, the people trying the impeachment are basically on the side of the person being impeached. The Senate and President will form a combination that cannot be prevented by the representatives. In its present form, the guilty try themselves. The president is tried by his counselors. So Mason as well was warning, this is just not going to work. But yet they did not. Henry, Mason, and a few others, they did not convince enough people that this power was so ineffective that they shouldn't ratify. So they went with it. They kept that power. And the result, Thomas Jefferson, just 30 years, this is in September of 1819 in a letter to Spencer Roane, 30 years after the Constitution went into effect, he agreed. He felt that the impeachment power in and of itself was little more than window dressing. It was totally ineffective. Here's how he put it. For experience has already shown that the impeachment it has provided is not even a scarecrow. So after hearing all of this, I'm actually curious. What do you think? Which side was right? The Federalists who said this was going to be a tool to protect the Republic against all kinds of serious abuse of power? Well, the Anti-Federalists who said, well, it's just window dressing. It's a sham. It's a farce. On my end of things, I don't always take their side, but I'm 100% on Team Patrick Henry and George Mason on this. Absolutely. And of course, hindsight is 20/20. It's easy to say they called it. They knew something was up. They didn't think that combining the Senate and the impeachment trial on this was going to work. That no one was going to get removed. But certainly they were on to something. These weren't dumb people here, Patrick Henry and George Mason. And Thomas Jefferson, he got that 20/20 hindsight in just 30 years. We certainly can catch up to him as well. So I'm curious what you think. Federalists, Anti-Federalists, you can give me an A or an F in the comments or let me know a little bit more. I appreciate your feedback and I appreciate you watching. Unfortunately, though, because of the government-run and I guess government-approved so-called education system, very few of any of us really learn any of this stuff in any detail. And that's a huge reason why we work so hard every single day here at the 10th Amendment Center to reach and teach more and more people about this essential and forgotten history from the founders, from the old revolutionaries, about the Constitution and how to enforce it. And nothing helps us do this work more than the financial faith and support of our members. If you got a couple of bucks of that quickly devaluing dirty government fiat, please consider throwing it our way over at 10thamendmentcenter.com/members. It's all spelled out. Our membership program starts out at just $2 a month. We also have annual, 5-year, and lifetime options. And if, again, 10thamendmentcenter.com/members. And if you want to help us out financially, but you don't want to do a recurring or a membership of any kind, that's cool. There are many other ways to pitch in. You can send us some gold backs by mail. You can do a one-time contribution online over at 10thamendmentcenter.com/donate. All the information will be over there at that link. I'm very grateful for any consideration you give to putting your financial faith behind our work today. Thank you. There's also a bunch of free and easy peasy things you can do. This is a long episode, but one of the number one things that you can do to help us spread the word is to trigger the algorithm of the mainstream platforms. And on the video platforms, watch time percentage is a lot. I can't do math because I went to government-run school. I can't do it without my phone at least. But if it's a 10-minute video and you watch 10 minutes, that's 100%. That's pretty good. But 30 minutes is 300%. And that's really, really good. And that'll show us to even more people. Of course, reviews on Apple Podcasts or any other podcast platform, comments telling me whether Team Anti-Federalist or Team Federalist or whatever you want to say, or if you've got suggestions for other episodes, hitting the like button, reviews, comments, subscribe, notifications, all the things you can do to interact with these various platforms can definitely tell them to show us to more people. And I really appreciate your help. I really appreciate you spending some of your time with me today. I hope you enjoyed this episode. I hope it was interesting. I hope it was educational. I hope it was entertaining. More important than anything, I hope it made you think, and I hope you learned something. Again, I really appreciate you spending some of your time with me today. I hope you have an awesome weekend, and I'll see you next week, just Wednesday. I'm off on Friday, just next week, Wednesday, here on the Path to Liberty.